I'm going to focus on governance of an emerging suite of possible ways of addressing climate change, which fall under this rubric of something called marine geoengineering. Now, as we all know, the Paris Agreement set up the salutary goals of seeking to hold temperatures to quote unquote well below 2 degrees Celsius and at least aspirationally below 1.5 degrees Celsius. Unfortunately, what we're seeing is a massive disconnect between the pledges that have been made by parties to meet this goal and what actually needs to be done. And as a consequence, many climate scientists now say that instead of holding temperatures to well below 2 degrees Celsius by the end of the century, we may be facing temperature increases of somewhere between 3.2 and 3.7 degrees Celsius, with temperatures continuing to rise for centuries after that due to the inertia of the system. And as a consequence, there's been increasing interest in the so-called Plan B, which are large-scale technological interventions into the environment, defined broadly as climate geoengineering, to seek to hold temperatures below critical thresholds while we decarbonize the world's economy. A lot of these geoengineering approaches have been either atmospheric based, such as putting large amounts of sulfur dioxide into the stratosphere to attempt to reflect sunlight back to space, or terrestrially based, such as direct air capture, erecting gigantic machines to suck carbon dioxide out of the atmosphere and then subsequently store it, or bioenergy with carbon capture and sequestration. However, there's also been on a parallel track increasing interest in efforts to utilize the world's oceans, which already store substantial amounts of carbon dioxide as a means of helping achieve these goals. And there's been a large array of marine geoengineering approaches that have been discussed. These include things such as so-called ocean foaming or bubbling, where foams or bubbles would be placed on the ocean surface to try to increase its albedo or reflectivity, and as a consequence exert a cooling impact. Or cloud seeding, spraying salt water into clouds to make them brighter and thus reflect more sunlight away. Other approaches include something called ocean alkalization, which is the idea of seeding the world's oceans with materials such as limestone or olivine, highly silicate materials that would create carbonate and bicarbonate materials that ultimately would store carbon dioxide at the bottom of the oceans for hundreds of years. Ocean iron fertilization, which would seed the world's oceans with iron or phosphorus or nitrogen to try to increase production of phytoplankton, which take up carbon dioxide in the photosynthetic process. And the idea is that when these phytoplankton would die, they would take that carbon dioxide to the deep recesses of the ocean, again, for hundreds of years, buying us time as we try to get our act together in terms of reducing greenhouse gas emissions. Artificial upwelling, which would pump water from the depths of the oceans to cool the surfaces, and so-called blue carbon solutions, such as increasing the use of or increasing the production of algae to take up carbon dioxide. Now, while all these approaches potentially have benefits, they virtually all pose risks, especially at a large scale production. For example, ocean iron fertilization, for which there's been a number of experiments over the years, could potentially rob downstream areas of critical nutrients, and as a consequence wreak havoc with ocean ecosystems and other areas, as well as fisheries. Similarly, it could produce phytoplankton species that couldn't be consumed by zooplankton species in the areas in which they were produced. And as a consequence, zooplankton could decline, and species that rely on those zooplankton could also decline, which could create a trophic cascade effect in ocean ecosystems. It could create massive toxic algae blooms that also could have serious implications for living species in the area. Ocean alkalization could potentially change ocean temperatures to the point where it created profound biogeochemical changes in the world's oceans, which again could potentially adversely affect ocean ecosystems. Or it could release toxic substances in some cases, such as nickel or chromium, that could have impacts on ocean ecosystems, and so on and so forth. And so as a consequence, one of the questions is, if we are to proceed with research in this context and potential deployment, what are the ways that we might govern these approaches? And so I very briefly want to look at some of the approaches that have already been developed and might be further developed in terms of some of these technologies, and other regimes at the international level that might be relevant. And I would emphasize at the outset that any of these that occurred, of course, in coastal areas would obviously also be subject to domestic regulation, but I want to focus on the international regulations. Two regimes to date have sought to address marine geoengineering, at least in the context of one of these approaches, which is ocean iron fertilization, which, as I said, has had a number of field experiments in the world's oceans and has attracted the interest of a couple of treaty regimes. The first of these is the London Dumping Convention. So the London Dumping Convention passed a resolution in 2008 that sought to regulate ocean iron fertilization, and it has several components. One is that it restricts ocean iron fertilization activities to quote unquote legitimate scientific research. In other words, no ocean iron fertilization can occur for the purposes of obtaining credits, for example, in voluntary carbon markets for the carbon that might be sequestered. Second of all, it requires the use of a risk assessment framework, which was to be developed by the scientific groups under the convention and its protocol, right? And as I said, it foreclosed all other kinds of activity. Now, this resolution was restricted to ocean iron fertilization, but it's likely could provide a roadmap for the regulation of other marine geoengineering approaches in the future. And subsequently, the parties to the treaty did establish a risk assessment framework for ocean iron fertilization in 2010, which again could potentially be a template. Now, there are obviously limitations to this approach. First of all, as we know, the resolutions that are passed by most regimes, and that includes the London Convention, are not legally binding on the parties. It's likely to have a persuasive influence in terms of how these approaches would proceed, but it doesn't create a mandate. And then second of all, as emphasized above, at least as currently structured, it would only regulate ocean iron fertilization. So if other marine geoengineering activities were to ensue, the regime would have to expand its purview. Another possible way to regulate this in the context of the same regime is under the context of the London Protocol to the Dumping Convention. And in 2013, the parties passed a resolution that would amend the protocol to regulate ocean iron fertilization most specifically, and potentially other marine geoengineering activities. And so, as you can see, it expanded the purview to all potential marine geoengineering activities, though initially only regulating ocean iron fertilization. It required permits by the parties and mandates to limit or reduce pollution in the case of these activities. And again, it would only allow these permits for legitimate scientific research and no commercial activities, at least initially. And it would establish an assessment framework that would be identical to the one that was established in 2010. The difference here, of course, is as an amendment to the protocol, this would be legally binding on the parties, and thus would have more impact. But it should be noted that the influence of this is also limited in a number of ways. First of all, the amendment only comes into force when 2/3 of the parties have accepted it, which would require 34 parties to do so, and currently only 4 have accepted. 4 parties to the protocol have accepted it. Moreover, the protocol only binds 51 states, and it doesn't include one key potential actor in this context, which is the United States. The other regime that has also sought to regulate ocean iron fertilization is the Convention on Biological Diversity. It passed a resolution in 2010, and as you can see here, it essentially provides for the same thing as the London Dumping Convention. It restricts ocean iron fertilization activities to scientific research. It says it must be small scale, though it doesn't define what the scope of small scale is, and it requires a risk assessment framework. And they embraced the framework that was established under the London Convention as a potential model. Beyond these regimes, however, there are others that would be pertinent if marine geoengineering research or potential deployment would occur in the future. And I want to very briefly talk about what those would be. One obvious candidate would be the United Nations Convention for the Law of the Sea. Now, under UNCLOS, there is a capacious right to conduct marine scientific research under Article 238 and 239. And so this could help facilitate marine geoengineering research in the future. At the same time, of course, if this research were to occur in territorial seas, it would be subject to Article 245, which would allow coastal states to exert control, albeit they would have to exert this control and decide whether to allow this research in good faith. Now, beyond the exclusive economic zones, there's also a capacious right to conduct marine scientific research under Article 257, but there would also be the potential for state responsibility and liability should that research result in negative impacts, either to coastal states or to the global commons. In the case of large-scale deployment of these technologies, as opposed to merely research, there's several provisions that would be pertinent. Article 194, which talks about measures to reduce and control pollution, might be relevant. For example, if some of these approaches were to release things such as nickel and chromium, as it's talked about in terms of ocean alkalization, or toxic manifestations from ocean iron fertilization, it would be subject to 194. Moreover, the definition of pollution is broad enough to include a large number of the approaches that we talked about, right? The introduction of substances or energy into the environment that could have deleterious impacts. Moreover, the emerging BBNJ, Biodiversity Beyond National Jurisdiction regime that would be developed would also potentially have several relevant provisions, including its provisions for marine protected areas, which might restrict the scope of where marine geoengineering activities could occur, and its requirement of environmental impact assessments, which would probably mandate cooperation and communication with other parties that might be impacted by these activities should they occur on the open seas. The Paris Agreement obviously could be potentially relevant also. One question would be whether you could claim marine geoengineering as part of your nationally determined contributions, right? The pledges that you make. These contributions are to include domestic mitigation measures. And while the term mitigation is not defined under the Paris Agreement, under the Framework Convention, it does include efforts to protect and enhance sinks and reservoirs, so things that take up carbon dioxide. So I think a good argument could be made that at least these approaches that would sequester carbon dioxide, such as ocean alkalinization or ocean iron fertilization, would constitute mitigation measures, and thus the parties could claim that utilization of these approaches could be part of their nationally determined contributions. At the same time, even if they did not claim that they were going to utilize marine geoengineering as part of their NDCs, parties to the Paris Agreement would be subject to other provisions that might regulate and limit the scope and approaches that might be utilized. For example, there's preambular language that indicates that when you take measures to address climate change, not just the impacts of climate change, but measures to address climate change, you have to quote unquote respect, promote, and consider obligations in terms of human rights. And it could be argued, for example, that if one were to rob downstream areas of nutrients by deploying ocean iron fertilization, this might contravene the right to food or the right to subsistence, and thus be subject to scrutiny in terms of human rights implications, as well as any negative implications on health that might occur in terms of these approaches. And it also talks about in terms of response measures, impacts on sustainable development. And so any of the sustainable development goals that would be pertinent here, including protection of the marine environment and the integrity of the marine environment, might be potentially relevant as the parties proceed. Of course, this is preambular language, so it's not legally binding on the parties, but again, it might guide how marine geoengineering would be considered and taken up in the context of the Paris Agreement. And then finally, I very briefly conclude and say there would obviously be customary international law principles that would be pertinent. This would include the no harm principle in cases where marine geoengineering approaches might have transboundary impacts, either in terms of other countries or the global commons. The precautionary principle, which of course could cut either way. One could argue that it would cut against utilizing these approaches given their potential negative impacts, but it could also be argued, given the catastrophic impacts of unchecked climate change, it would make sense to proceed with some of these approaches, and that would have to be sorted out by the parties. And again, the obligations to engage in transboundary environmental impact assessment, which has been recognized by the International Court of Justice, would also be potentially pertinent. And so I see my time is up, and so I'm going to conclude by saying that it is likely that climate geoengineering approaches, for better or worse, are going to be increasingly scrutinized by the parties to the Paris Agreement, given our inability, it seems, as humans to effectively reduce greenhouse gas emissions. And it's likely that marine geoengineering approaches will be part of this calculus. And so international law will have an important role to play in determining if we proceed with some of these and how we proceed. Thank you very much.